Good afternoon, ladies and gentlemen. It's quite hot this room. So climate change is obvious actually. We now in September, but the temperature in the morning and afternoon quite same as the summer. How would you choose your holidays? Was it phonetic or fanciful? So actually worship. And public issue now contended maybe from a prosecution officer of Korea. Ms. Che, chief prosecution officer, was allegedly unethical. How do you see many issues and controversies about the truth of whether they actually said to have improper and unethical conduct as a government officer. It's an honor to have a weather baby. Actually, a flag of a public opinion launched against that. Is it legitimate? The NIC intervened to manipulate the kind of a presidential election last. Is it true? How do you believe it? Actually, one chief officer of NIC was accused in violation of national election laws. It's a sensitive issue nowadays. Of course, the nature of controversy involves the ethics of a government officer. Actually, we introduced the state terms of 2 years in the purpose to ensure independence of quasi-judicial law obtained by KPO, Korean Prosecution Office. It goes saying in Polish purpose like else. Independence of judicial, rule of law concept, based on that idea. However, it is actually curious if you see many discontinuance of a chief prosecution officer. It took, as far as I know, 12 officers from 18 appointments quit their job during the terms. So the list of intent was critically discouraged and actually exposed some of representative about a manifestation, often which often happened in the Korean context. Okay, as I've said, you are advised to drop by mailbox, 6th floor in the low building, so you may have in the box a name, what indicated in my name, Kyung-Kim. So you can recover the printouts in coverage of a class discussion. I have done twice. Once again, you're advised to that. Might be through, in the week context, until the end of this term. I'm not sure, but that will be probable. did not exhaust the whole of a international contract. So we may return later, but in this class, my purpose is to expose you some of basics about international sales law. What is international sales law? Sales law is a dominant area in terms of contract law. So among the 14th statutory models provided in Korean Civil Code, the sales contract appears the first a priority, see, and then what borrowing contract or labor contract, construction contract, many other types of contract in which spans across a class of 14. The international contract, as I've said, more variances and types of contract, since the business need would flourish more than a domestic context of law, contract law. So, as I've said, the party autonomy is more important in the area of international contract law, while the concept would penetrate both dimensions, domestic in the same force, but it is more demanding if we engage in international business transactions. As you see in the projection, I've outlined basic topics delivered in this class. We first begin with the choice of law and conflict law laws, and then we'll overview commercial sale of goods, parallel evidence rule, and CISG. In the printout, you can see is the point that this section would purport to. So it actually CISG dominant law. It prevails over West context of a sale of goods in the United States. You have other source of law, which probably more important than CISG, uses the Uniform Commercial Code. But the increasing importance of CISG could be charted recently, and the section facilitates your viewpoint between those two norms. The comparison is also applicable to the Korean context, since we are also a signatory state of CISG, and we have a domestic commercial code. So the discussion in analogy and purview may overlap. So, can give us a lesson to deliberate on the point of international sales law. Most notably, CISG adopted a non-formality principle. So formality of requirement, for example, statute of frauds, or a parallel evidence rule as developed in the Anglo-American system of law would be contradicted in some area of concern. Actually, the practical consequence is not serious, but the annoying, the annoying business people make some damages or loss if we lost our eyesight between about differences between CIC and UCC. So we have two cases which gave us some practical points in consideration about this issue. And also in indication D, you see a CIC and Uniform Commercial Code. So the printout describes in neat fashion and a very organized summary form about the differences across the elements of a contract law. So for example, mechanics of formation. You see one pertinent case law decided in 1991, Pratt versus Whitney Corp versus Mary Hurlington Airlines Metropolitan Court of Budapest. We usually learn the context, the operation of offer and acceptance to make an agreement, a bearing contract. Is the agreement a bearing contract or not? Actually, meeting of the minds, an essential element we often require to see the bearing contract. And there is some points of our consideration where the very contract exists. Actually, form and enforceable as a matter of law or kind of regulation. Within what period of time the offeree can make acceptance, who is empowered to make a contract binding. And also, in that context, we see some different rules between a receipt principle and a mailbox rule. Mailbox rule, as I've said, allows the offering in a more stable position usually. So since what his responsibility is just to place the communication into the context where it has a official probability to reach the domain of a offerers. How do you see? In Italian context, even the effect of communication would be required of a knowledge element. So the addressing of communication needs to have actual knowledge about about the content of ideas dispatched to him. So in a spectrum, you can see four types in terms of effect of communication. Dispatch, a mailbox rule, interchangeably used to indicate, and receipt rule or knowledge rule. Or in extreme cases, the effect of communication may occur when the communicators complete his idea in written forms or oral. So 4 principles may be conceivable. And actually, there will be a point whether, determining whether the contract was valid formed or not. And next issue, titled a deadlock form. And this problem is notable in the preserving international contract, since the commercial merchant in international market often predominantly, most always use a standard form to make it a purchase offer or acceptance. So it often has 5 print on the back side, and also terms and conditions in details, which the parties would dislike to acknowledge in detail, since it actually prepared to counter some of extreme exigencies or a failure situation of contract, so they don't dislike to see. So we may well doubt if the terms of conditions are actually agreed between both parties. So they have no genuine intent or mind to agree on the contract. So how do we see if the contracted terms may bar the formation of contract? If the contract considered to be formed validly, then what terms of conditions govern the contractual relationship? How do we circumscribe the terms and conditions which would be enforceable in the context of the specific contract? So we have 2 cases in this area of concern. Chateau de Chamas Wise LTD versus Bay USA, decided in 2003. And also we have another case titled Philanto SPA versus Challenge International Corp. This did in Southern District of New York Corp in 1990. And the other point to merit our analysis will involve contract information. So how do we interpret the international contract? Of course, the first priority should be given to the literal meaning of contract. So plain language would be superlative and powerful, most powerful, to define terms and conditions. And absent given some of difficulties about the plain rule and the plethora of sources about interpretation and express or implied agreement, then we will be required to undertake other means, for example, a totality of circumstances. Particularly, this idea would be prevailing if the parole evidence of oral agreement is also considered one form of valid contract. Also, there are many other contexts, partly because of a diversity of laws, jurisdictions, and also because some of civilized concept of a social attribute contract, some of a upstaging effort of a interpretable, for example, the court of justice, good by incorporating the idea about entirety of a circumstance. And one other point which is considered important to understand the differences between UCC and CIC would concern duty to inspect and proper notice. You may have a familiar concept, non-freeze notice. So this originates from German idea of civil code and a dominant fashion in many successors of that legal tradition. And it allows an additional period of time when the party breaches the contract. So it is required as a matter of law and statutory mandated to give a non-freeze notice. That is not a rule in common law system. Once a breach occurs, the common law automatically authorizes the non-breaching party has the right to the legal remedy, for example, damages, damage in most contexts, and voiding of the contract, which requires, however, a material nature of breach. So damages may be available, notwithstanding the extent of what harms or as neighbors context. So it does not matter whether it is material breach or not. So damages are always insured for the non-breaching party. However, the avoidance of contract comes different. That is not the concept in non-freeze notice requirement. The nature of breach is meaningless, and the non-freeze notice to knock the intent of a breaching party is important and required a statute required in a statutory ways to seek legal remedies, damages, or avoidance of contract. Also, both jurisdictions recognize the seller's right to cure in some minor differences if we go into details. And other concept adopted by CIC drafters would be anticipatory breach. This concept is one of orthodox principles in the common law traditions. The idea was incorporated. So that is in contrast with a German legal system or other continental laws. So there are some circumstances that the non-breaching party may invoke the remedy before the contract terms expires. There are greater certainty of a non-performance contract before the contract terms. Then the non-breaching party may claim his right as a matter of law as the institution slide concerning anticipatory breach concept. And the accompanying rule would be adequate assurance. So this effectively prevents the avoidance of contract based on anticipatory breach. So the unwillingness or greater certainty of non-performance is a requirement of anticipatory breach, but adequate assurance may terminate the right to avoid contract, even if the elements will satisfy the anticipatory breach may be present. And also, in terms of contract law, the damages would be an important concept. You need to stick to this with the courses. Some of comparison may provide it as class progress. And also, other institutions often section importantly in contract law would be reviewed in brief. First, for example, frustration, the force majeure clause, and limitation period. So, the success of international customary law for trade uses provided a strong foundation for an international convention on state law. Examples of expansion of international customary law in the area of commercial transactions are the universal acceptance of the International Chamber of Commerce Incoterm. So what is Incoterm? It's a glossary of trade terms. So it, as I've said, define the rights and duties according to each trade term. And its regulations relating to international letters of credit, what we often call UCP, Uniform Customs and Practice for Document of Credit. The major area lacking uniformity was the law covering the underlying transaction, the sales contract. The United Nations Convention on Contract for the International Sale of Goods has been the most successful attempt to fill this gap. Before this convention, we have some major context of international sales treaty, what I call Hague Convention. It often regarded as unsuccessful, typically because it has limited scope of membership, and also some legitimacy may be questioned by underdeveloped countries. Since convention could be considered equal between sellers and buyers. Who are sellers? Often the providers or sellers may be based on the developed countries. That means some prejudice in the eyes of scholars in developing countries against the developing states. The CISG, however, has a great achievement. And now in the year 2004, we can identify about 68 member states, and the United States also party to this convention. And China also adopted it as a norms, the commercial interest. And the institution and devices available in CISG has less of influence to reform the domestic code, what we see in the last class, UCL, Uniform Chinese Law. I have some identical, very identical nature between two norms, CISG and UCL. The CISG may become the foundation for uniform international law of sales for the 24th century. So, CISG is the norm which is internationally in character. However, its incorporation into the domestic legal system means it fairly operates as a kind of a domestic commercial code. So UCC, CIS, and CISG have dominantly no difference for the jurists of the United States, and also in practical operation. In theory, that could be distinct since one norm is international treaty, that is a domestic commercial code. Of course, the nature would bring some of a different treatment on a case-by-case basis. For example, choice of law would supervene what norm would govern the contractual relationship. So the parties freely elect which norm is governing. So CIS may be a choice opted for the contract. Or the scope of a agreement may also exclude some of provisions specifically, although they may invoke the CISG as a governing law of the contract. So the discretion and the types of agreement reached by the party is absolute and superior of all other arrangements. So it is dominating the contractual relationship. In that context, we see some contrast, which is typical. For example, you may agree that the New York law is applicable to the contract. In the end, UCC is a governing, should become a governing norm for the contract. That agreement expressed in documentary, a written form of contract, would, however, incur some of difficulties. For example, CISG is also a New York law. So that type of agreement would blur the express to identifying the express intent of both parties. So more accurate provision may be, therefore, for example, CISG of New York law is governing law of for this contract. So more specifically address what norms of New York state would apply, govern the contractual relationship. Merely mentioning or writing a New York law would govern would not suffice to verify the intent about election of CISG as governing. Expressly mentioned CISG. Got the point? And most recently revised in 2001, the UCC is product of National Conference of Commissioners on Uniform State Laws and the American Law Institute. And of course, the American Law Institute is not lesser developer. They have no power to enact any binding nature of law. They're just competent. The competence is just limited to providing a model code or others. So actually, commercial matters is preserved within the state sovereignty. Okay? Each state legislature has authority to enact the state commercial code. And initially, it is most successful illustration you can see in United States legal history that 49 states, except Louisiana, ratified as a domestic commercial law. And now all 50 states and District of Columbia endorsed this model code as the state commercial code. The UCC covers many different topics, including sale of goods, commercial paper, and secure transactions. And those areas now within the scope of UCC, such as real estate, service contracts, are left to common law. So the areas covered by UCC would still remain within the common law preserve. So we have some needs, very strong needs to have a comparative analysis between those two norms, UCC and CIC. So it formalized the student with major sales law issues common to all legal systems, since both norms are actually most influential. As you see, the United States is the biggest trading countries, and also CISG, as I've said, is the representative international convention about the sales of contract law. And this, the in-depth review allows closer analysis of how these issues are treated differently among the nations. So, many illustrations I have mentioned throughout the class would be viewed as a new Lex Mercatoria. And we see some formulating agency in 20th century. Of course, predominantly in the initiative of the United Nations. So, UNCITRAL and UNIDROIT principles are notable institutions with pay attention about the formulating. So CISG adopted in 1980 marked the milestone in the development of new Lex Mercatoria, and it may well be combined with a UNIDROIT principles. We may return later for complementation of the plan. And the report of the restatement contract has predicted that CISG will become the governing law of most export and import of goods transactions. So that is the point, practically important, since the business people of the United States would see more importance to CISG rather than UCC. Restatement contracts are actually a secondary authority, but respected very highly about understanding the civil law and the comment of the report of restatement contracts with strong implications. The CISG went in effect in the United States on January 4th, 1988. And so, United States is a member state of CISG, but with one important reservation about clause 1990. So the concept is that the United States has need to obtain a membership of CISG, but the application of some of a complicated context of a jurisdiction question should be avoided. So in order for the CISG to be applied involving United States trade, would be limited to the first first class of jurisdiction. So the trading, the parties would have a place of business in different locations where the locations should be a member state of CISG. So that first principle only apply to United States because of that reservation. There are other possibilities that CISG may apply. The countries elected the choice of sources may be a signatory state of a CISG. Then there is no need that both parties have a different locations in terms of a CISG ambit. The national, the nation of a chosen law may be a signatory state which automatically affects the application of CISG. And another principle about jurisdiction also may be raised. We'll shortly return. And so CISG is an optional law. As I've said, the parties may opt out of it through a choice of a clause in the contract, even if the United States is a signatory of state of CISG. And actually, this point would be a factor which assuages the use of CISG in previous decades. So they have more credence on UCC, domestic commercial code. However, the rising context of international trade would blur. And now, as I've said, increasing importance is noted in comment of the report of restatement of a contract. As of a late 2004, the United Nations Treaty Section reported that 63 countries, sorry, 63, not 68, 63 countries have adopted the CISG. We have long hesitation to enter into CISG, but Korea also entered the CISG group in 2005. Actually, the commercial scholars and other concerned commentators, so some of maleficent context of provisions in CISG against the Korean traders and business persons. So part of reason may come from that, and other context also, I identified. But in any case, CISG is now one of a source of law for Korean commercial transactions. The coverage of CISG can be grouped into three broad areas: substantive coverage, jurisdiction, and types of transactions. The CIS covers most substantive issues, contract law. There are, however, areas of law not covered under the CISG, including products liability, the legality of contract, the capacity of the parties to contract, and whether the non-breaching party is entitled to specific performance. So major contract issues may not resolve. So it is very limited context of agreement. For example, it is devoid of a legality of contract. Whether, for example, the minor may enter a varied contractual relationship with others. And the legality of contract, of course, involves some of public policy issues, which may be critical to ensure the public order of one nation or others. So it is actually the area hardly reached in some form of consensus, or so that is a point that the drafters may like to avoid. To have written agreement. And these substantive areas are decided in the national law of contract. The national law to be applied is determined by applying the forum called conflict of law rules. So even if the CISG is the point, we have to impart a critical concern about understanding of this area of law. We would perhaps be right to begin with choice of law and conflict of law. It provides a bottom line and basics in the structure and as a matter of principle. The choice of law clause used to avoid application of CISG must be carefully drafted, and that is actually dominant practice, often witnessed in international contracts. So the parties may favor to reduce the agreement into express ideas on choice of law. The parties may intend the UCC to be the law of transaction. To that end, the parties negotiate blah, blah, blah. So it should be clear, as I've said. For example, the law of the state of New York law shall apply to any dispute. Let's suppose this language in a specific contract. How could we see this agreement? In this case, on Article 11A of CISG, the law of the New York is the CISG if the two parties are from different CIS countries. So the language does not lead us to the application of UCC actually, finally. So it is one point the business people should be aware. Of course, many business people often sought some of a professional advice when they deal with some of important commercial transactions. So for such a quagmire, clear choice of law clause should be drafted. For example, previous choice of law clause should specify that the Uniform Commercial Code of State of New York is the applicable law. And I'd like to make a point about the jurisdiction of CISG. As I've said, you have 3 points in consideration. For example, Article 1 of CISG states that unless there is an express choice of law clause in the contract, the CISG will be the law of dispute in 2 situations. First, CISG will apply if the parties have their places of business in countries that have ratified the CISG. And in applying this jurisdictional clause, you may be clear about how to determine the place of business. There are many multinational enterprises now have branches across the global jurisdictions. Samsung is notable multinational enterprises. There are branches in the United States, some cities of the United States, Tokyo in Japan or Korea. So that context may raise some ambiguities about the element which operates in determining a place of business. So if a party has more than one place of business, the place of business is which has the closest relationship to the contract and its performance. Therefore, if a foreign subsidiary of a corporation enters into contract, the place of business for determining the jurisdiction of CISG is the location of subsidiary and not of the parent company. So the close relationship test would apply. And the second ground for CISG jurisdiction is when only one of the parties is from a CISG country. In that event, the court or arbitral tribunal is instructed to use the conflict of law rules to determine the law of dispute. So it is a matter of law that the conflict of law rules should have to find the applicable law. If the conflict of law rules direct the court or tribunal to the party whose country has ratified the CISG, then the CISG becomes the law of dispute. Note, however, that the United States opted out of second ground for jurisdiction. So the U.S. Court of Arbitral Tribunal will apply the CISG only when both parties are from different CISG countries. So the U.S. authority will dislike to see some of a complicated nature of a jurisdictional issues. Without this reservation, the transage of CISG would multiply unexpectedly, since operation of the agreement, party autonomy. The third ground for the use of CISG in a dispute is based in customary international law. An arbitral panel or court may use the CISG as evidence of trade uses instead of applying the law of individual country. So, it is not dominant, but may be occasion in a selective context that the parties agreed on trade uses or other a customary law, international custom, that is actually ambiguous about what the accurate, precise intent of the parties are. In that event, the CISG may operate as a gap filler. So one case may exactly mirror this context. International Chamber of Commerce arbitration case number 5706 13 of 1989. In this case, the contract contained no provisions regarding the substantive law. So there was no choice of law clause. Under such circumstances, the arbitrators usually apply the law designed as the proper law by applying conflict of law rules that they deem appropriate. So they may have to seek a conflict of law rules, since they have to shape some of substantive scope of substantive laws applicable to the contract. The law of country and the arbitral tribunal has some more latitude than a national court judges. So, in choice of conflict of law exploration, they may have leeways, more leeways as compared with a national juries. The law of country of seller appear to be the proper law governing the contract. Instead, the tribunal found there is no better source to determine the prevailing trade uses than the terms of CISG. This was so, even though neither the country of buyer nor the country of seller was a party to the CISG. So, the flexibility of arbitration may enable to invoke a CISG as an international customary law. The issue in the case was length of time a purchaser had to give notice of defect. The arbitration tribunal disregarded the domestic law shorter statute of limitation period in favor of 2-year period provided in CISG. So the arbitrators often see some of uncivilized nature, lacking universal appeal, and or some of authoritative to fail the concept of justice, concept of fair justice, kind of. So 2-year period endorsed by a civilized, dominant civilized countries may become a source of law, international custom, overriding some of discrete nature of a specific national laws. In short, the arbitral tribunal used CISG as evidence of international trade uses to avoid what it deemed to be an unfair domestic law. The arbitrator's decision stated that as the applicable provisions of the law of the country where the seller had his place of business appear to deviate from the generally accepted trade uses as reflected in the CISG, in that it imposed extremely short and specific requirements in respect of buyer giving notice to the seller in case of defect. The tribunal elects to apply the CISG. This voluntary application of CISG as evidence of a customary international law should not come as a surprise, because the CISG is the product of compromise between the world's major legal systems. It possesses a universal appeal. Many arbitrators find beneficial in the search for explanatory type of justification for their words. And also, you may note that CISG was drafted in the clear and non-legal language, so forced to be applied universally across the jargons of each respective national civil code. So good source of supranational rules of commerce. And CISG, also UCC, despite in some different expression, in CISG you see sale of goods. In comparison, UCC covers transactions in goods. So some may entail some different connotation specifically, but dominantly same, goes same. But however, you may see some delicacies and differences. In any case, what are the commercial sale of goods? Both norms are expected to play within. There is the threshold question about our deliberation. The CIS covers only a transaction for the sale of goods. So dominantly, it provokes no problem, since we may have tangible goods in commercial stream, international stream of commerce. However, there are some difficult situation which involves, for example, a mixed sale. So the transaction may involve trade of goods and a license of technology or a computer software or some provision of service. So you need to say that a provision of service does not fall within the class of a sale of goods, and also license of technology does not pertain to the sale of goods concept. And three pillars are also dealt with in a different section of WTO laws. So TRIPS agreement, as you see, a GATS, General Agreement on Trade of Services, and 1994, a GATT, General Agreement on Tariff and Trades. And in the dimension of public law, the controversy about the nature of a transaction also arises. Right? Is this the matter dealing with a trade of goods or trade of services? Notably, the e-commerce, a new surge of informed and interchange of international trade, actually complicated the exact identification, the definition of the nature of trade. Is it pertaining to the service trade agreement, or does it matter, that should be considered in the perspective of a 1994 GATT? That is the point now raised in the advent of a e-commerce era, and that is also pertinent to our class discussion, mixed sale. So the variance of a trade purpose involved in each transaction may require some type of mixed sale. So not purely concerning the trade of goods, tangible item. You may suppose, for example, a disk or CD-ROM transaction, disk or CD-ROM. Then a service or technical assistance agreement and a license pertaining to intellectual property rights would be involved. So, how do we define this type of mixed sale? Can we properly apply CISG or UCC to this type of transaction? The CISG Article provides a two-part test to distinguish a service contract from a sale of goods. What's the point? First, the contract is not for the sale of goods if the buyer provides a substantial part of the materials used in production of the goods. This would be considered a contract for labor or assembly services. Second, a predominant part of the contract must not be for the supply of labor or services. So in the case to fit this requirement, the contract may go outside the scope of a CISG. This kind of problem or mixed sales also could be addressed in the application of UCC. So one case titled Micro Data System Incorporation versus Durham Systems reveals this context of interplay. So this case involves the transaction of a component part of a good. In that case, the buyer agreed to pay $125,000 for software and $125 for services necessary to adapt the system to the buyer's needs. So it's mixed sale. The court ruled that the service were not services to be rendered directly to the buyer, but merely the labor to be extended in producing the modified software. As a result, the court concluded the transaction was a sale of goods. And a computer software sale frequented in this contemporary times also normally mixes the characteristics of sale of goods, sale of services, lease or license technology. Because software possesses both tangible and intangible elements. So let us apply the Article 3, second test available in CISG. The software sale will then be considered within the scope of CISG only if a predominant part of transaction is for tangible goods. So we may look to the allocation of the price when the contract involves a multiple nature of a provision, service, tangible goods. So let's suppose if $20,000 worth of database software and $15,000 worth of support service and labor for data entry. Then the contract would be considered a predominantly one for sale of goods and covered by CISG. So it is a delicate point in terms of legal issue, and one commentator suggests the concept of virtual goods. Since many types of a contemporary transaction involve difficult aspect which disable a straightforward and concept of nature of transaction. So the concept virtual goods would facilitate many dubious area in defining the nature of a trade. So, of course, you may know, it is a threshold issue we have to define in finding applicability of a CISG and UCC. So, UCC, as I said, covers transaction in goods. So its coverage is limited not to sales, but by the word a transaction. And in contrast, CISG expressly uses term sales. And the concept of movability about definition of goods is critical and determinative in circumscribing goods. The crucial determination of CISG applicability is if the sale of a copy of software along with the license for its use is considered the sale of goods. Generally, transfer of items by way of a license are considered not to be sale of goods. Software licensing agreements, however, often have the characteristics of sale of goods transactions. If the copy being licensed is one for perpetual use, for which the licensee paid a one-time licensing fee, then the software is essentially being sold, even though the license retains title to the software. The substantial perspective in those classification as a sale of goods. So the ownership of technology is superficial in this context. The licensee becomes the owner of the copy in a substantial aspect. The attribute is considered substantially for a sales concept. The CIC is likely to cover sales of off-the-shelf software. And you now on item C, parallel evidence rule and CSJ. So as I've said, the concept, the parallel evidence rule or statute of frauds are basic, and some of forefronted a premise, the common law jurisdiction long upholds. However, that will not be found in CISG. So there is some area of a requirement, a statutory requirement for a varied contract, enforceable contract. In order to find an enforceable contract, some classes of contract should be concluded in written forms. Writing requirement is mandated. Some writing sufficient to indicate the contract of sale has been made. Must evidence any sale of goods for a price of $5,000 or more. So the idea is to give some weight for the contract beyond some extent. $5,000. So it should be entered in written form. This same section of the UCC requires that the party against whom enforcement is sought must have assigned the right. And another concept in this context of common law may come in the name of a consideration. So that is also distinct area of law that the civil law concepts would not endorse. So how do you perceive this legal institution? Actually, it enables the parties to be engaged more serious about their contractual relationship, written forms, and some fair concept, and also minimal preserve to signify the contractual meaning would be secured by requirement of consideration. So the idea also is historical and also based on some of a premortal concept about society and economic transactions. How do you perceive? That is not the case for the continental state. And now formality is not required, as we have reiterated, and also in some abstract form of entering into contract is also endorsed by law, so without consideration. So the central point to validate the contract would be the meeting of minds. There is no need about a consideration, so many remnant to engineer the parties in the contract would not be considered essential. How do you see? That is not the case. The CIC applies the view of many similar countries. The writing is not required to enforce an agreement. By the adoption of common law parallel evidence rule, the UCC writing requirement or a statute of fraud also prevents the admission of evidence that contradicts the writing. So in this context, the arrangement may confuse the common law lawyers and business people, since actually international business transactions is processed on lengthy negotiation and many communications and letters were exchanged by the parties, to which may finally, which enable finally to enter the contract into any written form of law. And so the concept would arouse a fear if the contract may be viewed as concluded, given some of a partial comment or some of oral exchange. It is fearful that the U.S. business people often like to avoid. So lengthy negotiation may enable the kind of a confusing situation. They, in their letter, some of intent to praise the negotiation and most wonderful to see your terms and others. And also they may have informal meetings to discuss the matters and exchange some of ideas about its merits and some a clause about your proposal. The kind of oral exchange may be interpreted in the fear of a U.S. business people for a buried contract. So their attitude is fairly determinative about the written form of contract. So they often see the final form of written contract as a contract. And they also disfavor some of constructive engagement or involvement of a core authority or public. Of course, that is a matter of relativism and may be different on a case-by-case basis and across the times. So in this contemporary times, that is not the exact case in some aspect for the U.S. business people. However, traditionally incorrect, not incorrect, to say that U.S. business people may fear of this kind of rule, statute. So absent a statute of prose or parallel evidence rule, the U.S. business people may go very unstable and other institutions provided by UCC as pertinent to this deliberation would be a written confirmation rule and an order for a specially manufactured good, and cases in which the party's conduct has overtaken the lack of a sufficient right, such as when payment or receipt of goods occurred. What is the written confirmation rule? This rule is available only in commercial transactions because it requires both parties be merchants. It states the writing sent by one of the parties confirming the conclusion of contract is sufficient to satisfy the writing requirement. So it is some form of variance against the statute of frauds. So the statute of frauds, in rule requires the signature of a bound party. So in order to pursue the contractual duty, or then the party sought to be remedied, or to be claimed about the contractual duty, must sign the contract. He must be signed to the contract. Okay. That is modified in the written confirmation rule. The other party did not sign or acknowledge receipt of confirmation to be bound by. Section 201 does allow the receiving party to object to the confirmation and thus prevent the formation of contract. The notice of objection must be given within 10 days of receipt of written confirmation. And what is the parole evidence rule in the U.S. common law jurisdiction? It seeks to preserve the integrity of ambiguous written contract by refusing to allow the admission of oral statements or previous correspondence to contradict the written agreement. Under this rule, when parties place the agreement in writing, all previous oral and written documents merge into the final written agreement. Of such final written agreement may be explained or supplemented by prior dealings, trade uses, or course of performance information. What is prior dealings? So it is a great source to supplement the written form of contract. So the rule concerns an evidentiary aspect of a civil dispute. So it is distinct from the state of frauds requirement, since that deals with the substantive matters of law. Is a valid contract form or not? That is not the case in parole evidence rule. So the prior dealings may not be erased as an evidence in the courtroom, and trade uses also comes in the context. So in this concept, what are prior dealings? It includes prior contract and performance between the parties that establish a common basis for understanding and for interpreting a subsequent contract. What are trade uses? It refers to the customs and practice regularly observed in a given trade or business. These uses furnish the background and give meaning to the language used by merchants in that trade. What is a course of performance? It is premised on the fact the parties' conduct in performing under the contract is a good indication of what they believe to be its meaning. Section 208 of the UCC states, however, that any course of performance accepted or acquiesced in without objection shall be relevant to determine the meaning of the agreement. So these concepts may operate to explain or supplement the written contract. And in concept, they are considered to be incorporated finally into written contract. And this approach actually comes in perverted way in CISG. Article 11 of CIS states that a contract may not be concluded in or evidenced by writing. So the principle of simulates the civil law traditions. So in terms of CISG, the contract and its terms may be proved by any means, including witness testimony. Therefore, the potential for liability for representations made during the negotiation stage is greater under the CISG. That's the point I made a precaution in the context of US business people. So they should be scrupulous about its impact of the oral statement or others. And it also involves the lengthier context of negotiation. So the UCC's parallel evidence rule allows a party to avoid liability for statements during the negotiations if those statements are not placed within the final written contract. Under CISG, prior oral statements regarding anything, including quality and performance, are potentially enforceable. That's the point of distinction. So an unknowing American business person needs to have that point in their engagement. The CISG lack of writing requirement is further complicated by Article 12 and 96, which now allow contracting states to opt out of Article 11's lack of writing requirement. Some countries, mostly the countries of former Soviet Union and socialist law countries, have opted out in favor of domestic laws that require writing. So as I mentioned previously, the socialist tradition of legal system often sees its importance as a matter of law of writing and some public notarization or a document shared by the governmental branches or others. So the formality of contract is more highly required in the context in comparison with a common law country. So Russia, Ukraine, Belarus, Estonia, and Hungary. So these drafters of CISG also left some niche to have a breathing space about non-formality requirement. So it is actually delicate across the global jurisdictions. So articles 12 and 96 may purport to serve that end of CISG, and socialist countries frequently use this exemption. We'll later review some decision made by High Arbitration Court of the Russian Federation. And actually, a socialist legal system often sees the arbitration in an important instrumentality to penetrate the business transaction. So many arbitration codes are installed and also operate to serve the justice on the commercial transactions. It is typical against the capitalist countries. Often national courts have more dominant authority to deliver a justice on business transactions. That is not the case. The arbitration court would profile a more strong force in this point. So in this case, you may consider kind of highlights. Article 12 of CISG permits contracting states to opt out of Article 11 and require the contracts be memorialized in writing. Point in need of your further review. And the Russian Federation, through obligations, the past trade from the former Soviet Union, has opted out in favor of a domestic laws that require written contract. And another point. The writing necessary to meet the requirement of Russian domestic law may be informal, such as a facsimile or similar document. At this point, it also raised once in a Korean jurisdiction. So facsimile transmission is a unique source to ground the entrance into contractual relationship. Is it legally verifiable? When we consider the effective formation of contract, and the signature party to a contract modification is not necessary to meet the requirement of Russian law, according to this decision. But rather may be evidenced by partial performance by the party sought to be charged. And you can see elements of distinction between CISG and Uniform Commercial Code. And in the printout, you may be available about a selected point which considered important, spanning from writing requirement, parallel evidence rule, formation, obligation of good faith, revocability of offer, acceptance upon receipt, battle of forms, fixing price terms, place of payment, throughout, impediment, exemption, and finally a general notice. And the provisions, articles, pertinent to respective point also made clear in the comparison box. So point for your later review. So actually, you can see the context of delay about recognition of CISG as a norm in the United States. And 16 years after its implementation in the United States, the CISG remained a complex unknown, a complete unknown to many business people and lawyers. So that trend, as recently is seen changing. The CISG, as a polish, must be understood and applied effectively by U.S. exporters and importers, because it not only places some unique responsibilities on sellers and buyers of goods, but also provides a number of rights and remedies not found in U.S. law. So it is required as a practical need to understand a difference, since this scope of difference may render the business critically influenced. In some cases, may falter the basis of assumption, and also have the potential to strike the anticipation. So, point. A CISG, in terms of a contract formation, covered Article 1 through 13. 12 through 14 through 12 fourths. Okay? So 11 clauses come into the class of a contract formation. And there are general provisions in coverage of Articles 1 through 13. And rights and obligations are set forth in Articles 25, 88. And finally, the last part of articles deals with the issue of ratification. And how do you see in legal process the formation of contract? We begin with the concept, offer and acceptance. And also the usual issue which arises in this context is determining the exact time of a formation in order to decide the effectiveness of attempted revocation by the offerer and attempted rejections by the offerer. So the offerer is the party making an offer to contract. The offerer is the party that receives an offer and is empowered to create a binding contract through an acceptance of the offer. A contract may be formed when the offerer invites the offerer to accept by the commencing of performance. So this incident, commencing of performance, is a legal element, so which makes the conduct to make a valid making a valid contract. Commencement of performance may not be sufficient, however. In some cases, you see that point. The notice requirement also should be combined to make a full effect about commencement of performance. So it must be notified within a reasonable time the performance has commenced. So the UCC states in that way. So without satisfying the notice requirement, the court may treat the offer as having lapsed before acceptance. And in this area of concern, we also have some point of distinction between the effect of notice, a made back through a knowledge principle and receipt principle kind of concern. And also China's unified contract law may have a similarities with a CISJ. And one other interesting example may be found in Hungarian jurisdiction. Pratt versus Rittenkoven, Mellor versus Hungarian Airlines. Mellor Hungarian Airlines. In this case, we have several points to consider. Okay? For example, although ships, vessels, and aircraft are excluded from the CIC, a set of parts for such items is covered by the CIC. So the area of application is negatively defined by excluding some of a goods in CISJ. So ships and vessels, aircraft fall within that class. But in this case, interestingly, the court found otherwise, that the sales of those goods may be reserved by applying CISJ. Interesting. And an offer is sufficient even if it allows the offeree to fix the quantity term at some later date. So the formation of contract that comes in some varying way without a normal context, and also provoke some separate dealings from dominant rules. And unconditional acceptance does not prevent the formation of contract. So the court found it may effect a entrance of a varied contract relationship. And other issues, for example, better forms, contract interpretation, include some of important points required to be considered. That will be deferred to the next class. Any questions? And we have left many cases unreviewed, actually. In a previous class, we have several cases about international contract law. And in this class, I have just mentioned the case names and some of case highlights, which would be revamped in further review about some of details of case law. Okay, thank you for your attention. Then everybody complete class attendance. See you in the next class.